Welcome to Understanding Remorse Bias and the Subjective Nature of Remorse in Legal Processes. I'm Belinda McCauley, CEO of the Beverly Hills Bar Association, and I'm delighted to be here today to introduce our speaker, Dr. Colleen Berryessa. Dr. Berryessa is an associate professor at the Rutgers School of Criminal Justice, where she's taught since 2018. Using interdisciplinary qualitative and quantitative methods, her research examines how psychological processes, social contexts, and attitudes shape the criminal justice system, with a particular focus on public perceptions of sentencing, judicial decision-making, and forms of punishment beyond formal criminal justice stages. Dr. Berryessa holds a PhD in criminology from the University of Pennsylvania, a BA in government and mind, brain, and behavior from Harvard University, and served as a CIRGE research fellow at the Stanford Center for Biomedical Ethics. And now let's get started.
Perfect. Thank you so much for that wonderful introduction. I'm going to share my slides. And it's wonderful to be here with all of you today. As that nice introduction said, I am Colleen Berryessa. I'm an associate professor at the School of Criminal Justice, and I will be talking to you about work that I've done and also kind of more conceptually other people have done on remorse bias and evaluating remorse in the criminal justice system and the potential for bias and kind of cognitive impairments related to the assessments of remorse. I will keep questions until the end in the Q&A box. And so if you have any questions throughout, please put that in there and I will get to them at the end of the session. So the pictures you have here on the screen that you see are probably something that might be familiar to you. These are pictures where when you look at these people, you might get a feeling or a sense of the kinds of thoughts and feelings and attitudes that they could be expressing. You see a lot of covering the face, you see frowns, you see people covering their eyes. All of these suggest that these individuals, potentially are upset, that they're having strong emotions, that they potentially feel badly or sorry for maybe behavior that they've committed or something that's occurred to them. And a lot of the things that we see here are, again, very common societally in our interactions with other people. Everyone here has wronged someone or been wronged in some capacity. You felt badly about what you've done. The other person has felt badly, and you've expressed remorse or you've heard remorse from someone apologizing for harming you in some capacity. These are, again, things that are not only, very common in our social interactions, but are also often these pictures that we see here, these feelings, these kind of affective or emotional displays are very common and are kind of expected from a lot of us in our interactions in society more generally. And this is also something that we potentially might expect, and decision makers in the criminal justice system might expect to see if a person in the criminal justice system, a defendant, is showing remorse for their actions. But it's not that easy. And as we'll talk about today, remorse and actually identifying genuine or true remorse is very, very difficult and can be really clouded by subjectivity and biases in a variety of different ways. So let's talk a little bit about kind of the commonplace definition of remorse. So remorse communicates a distressing emotion arising from acceptance of personal responsibility for harm against another person and can signal a defendant's perceived character. It often is described as a deep feeling of recognizing and condemning harm. It can involve other types or related emotions like regret, shame, and guilt. And often people, both within the criminal justice system and without, often treat remorse as a way to try to understand others, as a window into the true self and moral orientation of other people. This person feels remorse, they feel sorry for what they've done, so they're a good person. This is just a mistake, this is something that won't happen again. This person has taken responsibility, and it's something that we should really consider when we think about his outcomes. This also is something that we often use to, again, think about future behavior. So it's when someone shows remorse, we frequently assume that that implies that whatever has happened won't happen again, that the behavior and the harms that have committed are, again, likely to just be an error in judgment or a one-time thing. But there is obviously, evidence when people think about, individuals maybe showing remorse or apologizing for behavior in criminal justice contexts. There is some evidence to suggest that it is somewhat mixed in the sense that the showing of remorse doesn't necessarily always map onto those future judgments of behavior and what actually happens for that person and making future contact with the criminal justice system. When we think about normative remorse cues, so the things we might expect when someone is showing remorse, they kind of fall along the lines of those pictures that you saw at the beginning of the presentation. When we think about the kind of verbal ways in which people kind of conventionally and normally show remorse, we often expect people to apologize. They may say things like, I'm sorry, I feel so badly, I won't do it again. So there are things that we may expect to hear when someone is showing remorse. It often shows acceptance of responsibility. It often requests forgiveness for that bad behavior. And it often also potentially suggests repairing that behavior in the sense that they want to attempt to try to make it up to the person, whether that be restitution, whether that be repairing through some sort of act of service. Somebody's iPad got broken, you buy them a new one, some sort of version of a repair for that bad behavior. There is also a variety of affective or emotional cues that we might expect to see. So this again could be things like crying, making eye contact or lack of eye contact, depending on the context, having closed posture, hunched body language. All of these things might suggest just by looking at someone that they feel badly for what they've done and they're showing remorse. But there is some evidence to suggest that these are maybe viewed sometimes as being less reliable than other forms of remorse, and also are potentially feared to be feigned in the sense that people are worried that someone potentially is putting on something like crocodile tears, or attempting to look like they are remorseful when in fact they may not be. And then finally, the behavioral remorse cues that we might expect to see are, again, things like restitution, where you might, say that you want to make it up to someone, and then you actually do that act of service, or you buy that person that iPad that has been potentially broken. And these are not only, impactful because they require resources and they require effort, but they also have large amounts of effects and are very significant to victim healing and to making victims and those that have been harmed feel whole or feel better about the situation when these behavioral cues are in some way, implemented in an interaction that involves remorse after a person has been harmed. So all of these things that we've talked about so far are very much kind of, again, commonplace societal things that don't necessarily always involve the criminal justice system. Again, everyone here has either harmed someone or been harmed by someone, no matter how small that incident potentially was. And that is something, again, is that everyone has experienced in kind of their general personal lives. But remorse also really matters in legal contexts as well. As I mentioned, there is a pretty good body of literature to suggest that decision makers in the legal system often link remorse and portrayals of remorse to judgments about a defendant's character, about judgments about a defendant's future outcomes. They often also consider remorse when assessing rehabilitation and the potential for a person to change their behavior and to potentially avoid harmful behavior in the future. In sentencing context, it can also be especially important, and that's going to be the focus that we especially talk about today, although there are many other areas in the legal process, both in criminal and civil, where remorse is really important. And in a lot of, research that has been done, it is suggested that remorse can be even more influential to sentencing processes than many formal or legal factors. And then there is also, again, a large body of research to suggest that when a person appears to be remorseless or there's an absence of remorse, this has been linked to increased punitiveness in legal contexts in the sense that there are suggestions that the person, again, doesn't feel bad, the person isn't accepting responsibility, and therefore whatever outcome that might be suggested or supported for that person is thought to be punitive to, again, maybe potentially teach them a lesson or to potentially have them avoid future contact with the victim or keep them, away from members of the community in order to keep them safe and away from harm. So thinking about the little parts of the legal process in which remorse might be important, and again, because it is largely in a legal context, it is largely around this idea of making judgments of character and outcomes. It especially is important at stages of the legal process where individuals are making decisions based on those criteria, whether that be informal or formal. So as I mentioned, sentencing is the stage in which it might be most prevalently significant and influential. This might be related to mitigation, acceptance of responsibility, and these things might be, again, very influential when a decision maker, like a judge, makes decisions about a person's outcomes or about their placement in correctional facilities or aftercare or things like that. There are also suggestions that it's important during probation. I've done some work to suggest that probation officers also think remorse is important and they communicate that information to the court, particularly in pre-sentencing reports or investigation reports. And that often is something taken into account by a judge when making sentencing determinations, which can be really, really influential. Remorse is also really important at parole stage, which again, we're not going to talk about here, but this is something that has been found in research to be central to release decisions, despite it being something that's listed in a lot in many states in their parole board systems, where they have specific criteria that they're evaluating in order to make those parole release decisions. Remorse is not usually listed in those, but is often still very influential. And then also in civil context, again, we're not going to talk about it today, but if you're interested in it, I did write a paper about remorse bias that is kind of a more general overview that I believe was the paper that has been associated with this program. And it talks about how remorse, especially related to apology laws and civil settlements, torts, medical malpractice, and a variety of things, those things can also be especially influential in assessing punitive damages in those particular types of cases. So let's talk a little bit about some of the kind of nuances associated with expressing remorse in court, and then also the assessments of remorse once it's been expressed. So there are difficulties, again, based on the structure and kind of the legal process when it comes to remorse and kind of when it's portrayed, how it's portrayed, and how it's weighed in legal decisions. So one thing that has been talked about a lot in prior work is that there has been suggestions that sometimes attorneys feel uncomfortable with their clients expressing remorse earlier on in the process, a legal process, especially before determinations of guilt. They may discourage remorse or apologies to avoid the person potentially appearing to be guilty, to avoid that self-incrimination. And so that's been something that has been talked about, and it potentially can have a kind of a negative effect where a person might not show remorse until after that determination of guilt, and then during sentencing show remorse, and then the fact that it hasn't been shown can potentially shine the defendant in a negative light, where the judge feels that they now are, in a situation during sentencing where now it's very convenient that they're showing remorse where they had not shown it previously. As I mentioned, in civil cases, sometimes defendants will fear liability, and so apology laws, which again I won't talk about here, but I do talk about in the article, do help to combat some of the fears that particularly physicians and other individuals who might be at the heart of a medical malpractice lawsuit or torts litigation, and so those that can make remorse very complicated in those instances, and apology laws have helped, but has not necessarily remedied the situation completely. One of the things that is most, difficult about assessing remorse in criminal justice context or legal context more generally is that often there's very little time and very little information and resources that decision makers have when assessing remorse of defendants, in the sense that they sometimes will only have 5 minutes. They may have a couple of pages in a case jacket or something like that, and so they have very, very limited time to try to assess this person's background and all the factors in their case, let alone thinking about assessing the remorse. And so these time and limited information pressures often limit how deep these assessments can be and also how accurate they can be. And this kind of plays into a kind of core part of what this presentation is about how remorse, which again is something that we know is often used as a proxy or an indicator of a person's character, about their future outcomes, if they're a good person and what we should expect of them. We know that assessing remorse in this way is really subjective. And because it's so subjective in a variety of different contexts that we'll talk about through the rest of this presentation, it really offers a rich opportunity and setting for cognitive bias. And particularly when remorse displays are being shown by individuals with particular personal characteristics, defendants with these personal characteristics may show remorse in non-normative ways. They also might show remorse in ways that are very true, again, to their culture or to their gender or to their race or related to their mental health or a variety of different contexts. And it may not necessarily map onto what is expected of them by decision makers based on, their upbringing or their level of education or things like that. And so based on prior experiences and then particularly stereotypes towards people, these defendants with these specific characteristics, the ways in which they're showing remorse and the assessments of their remorse may be in some way filtered through this like lens of expectations of this cognitive bias. And that may mean that there are judgments about this person's remorse and judgments about their character that are subjective and not accurate, in the sense that there may be suggestions that the defendant's ability to show or feel true remorse is not there or is not being shown in the way that would be expected, and therefore because it's being shown in a different way, that it doesn't exist or what's being shown is false. And so there's a lot of issues here about making judgments of individuals who maybe have these stereotyped qualities. And again, I'll give you examples in a little bit about what some of these qualities might be. And this can lead to not only inaccurate assessments of remorse, but also negative legal outcomes for these defendants based on those assessments. So why are remorse assessments subjective? So it kind of goes back to, again, the bias angle that I was talking about. The ways in which we interact in the world are often very much shaped by our social interactions, but also based on our prior experiences, on our mental shortcuts, our stereotypes. And in a courtroom, it's the same thing, where the ways in which people hold themselves in a courtroom, their demeanor, the way they speak, the way that they act, the way they present themselves, all of these are shaped by who they are and about their background and their experiences. It's shaped by their culture. It can be shaped by their race. It can be shaped by their gender. It can be shaped by their experiences of trauma in the past. It can be shaped by having a substance abuse disorder or having a mental health diagnosis. All of these things shape how a person presents themselves, their demeanor in court, and it doesn't necessarily always map onto how sincere they are, in the sense that sincerity is not the only thing that shapes this demeanor. It's also shaped by all these other qualities. And because decision makers have to make quick assessments about a defendant, not only based on remorse, but based on other criteria as well, they often will look for things to make judgments based on. And there's, again, a large body of psychological literature that talks about this, and that these assessments based on this limited information, these specific characteristics, it often leads them to rely on stereotypes and mental shortcuts to make judgments about defendants. Again, drawing from prior experience with defendants, drawing on societal stereotypes in order to make judgments. And because remorse is, again, the social interaction where it's coming back and forth, someone is showing remorse and in some way conveying it, the other person is assessing it and receiving it. Often, because we're taught in our day-to-day in our society, based on who we are, based on our level of education, based on our own family history, all these things, we might expect certain cues to show up if a person's remorse is true, in the sense that we might expect certain conventional cues, a person to say certain things or show certain emotions or show certain behaviors if they're remorseful based on our own backgrounds and experiences. And so these conventional cues have been described in research as performing remorse, in the sense that people are potentially expected to perform remorse in criminal justice and legal context more generally. And if they're in more normative ways, the idea is that they might be recognized as being, remorse because they are these kind of conventional societally accepted cues. And if they're performing remorse in those narrative ways, it's more likely to be rewarded. And what happens is that often, again, most of the time, a defendant and a judge, let's say, who's making that remorse assessment, there might be very, very kind of stark differences in the background characteristics and life experiences, education levels, a variety of things between that defendant and that decision maker. And those differences between defendants and decision makers can not only impede expected expressions of remorse, it can also make it very difficult for the decision maker to recognize remorse in ways that are not conventional. And what happens is that sometimes, again, when remorse is being portrayed in a way that's influenced by another person's culture or a different type of mental health background or a variety of different other characteristics that might mean that the remorse is not being portrayed in more conventional ways. It means that remorse assessments and then also character assessments, because we know that remorse and character are often tightly tied together when people are making judgments about another person, it sometimes suggests that this could spiral into kind of a reinforced circle of cognitive errors and implicit bias. That means that the remorse assessment may not necessarily be fully accurate, and that also there might be bias towards that individual and their potential outcomes, their character, and then potentially, again, what might happen to them in the criminal justice context. In a sentencing decision, it could lead to, again, more punitive or harsh outcomes for that individual. So all of the things that we've been talking about so far have been now encapsulated into this, nice kind of term, remorse bias. It's a psychological phenomenon that I've been working on for several years. It's something that's also been talked about conceptually by legal scholars and a variety of other scholars as well. And the idea is that, again, it's this biased misreading, discounting, or disregarding remorse of a person, even though it's true based on implicit or cognitive biases. It's often triggered when expressions diverge from, again, what might be expected when a person shows remorse, and it's amplified by stereotypes about certain groups. And again, it doesn't necessarily mean that every experience that a person has when it relates to specific groups, that, every decision maker and every group are going to have the same type of interaction or potential for remorse bias. It often has to do with the jurisdiction. It has to do with the courtroom context. It has to do with the court culture. I was talking to someone about, their experiences, and they had a large defendant population who were coming from a particular culture, and they had a different set of norms that they looked for when interacting with those defendants because that was, again, based on where their jurisdiction was, on their geographic location and on the kind of culture of their courtroom. But in the research that I've done, and when people talk about remorse bias, they often say that it is particularly maybe most affecting the outcomes and backgrounds of specific defendants that kind of fit with different categories that are also stereotypically associated maybe with criminality and then also with violence. And so those that I have done research on, it might be specific racial and ethnic minorities, it might be non-dominant cultural backgrounds, it might be age, so maybe potentially those who are of a younger age, either juvenile or emerging adulthood, those who have previous or current gang affiliation, those with lower education levels or lower sociodemographic backgrounds, psychiatric diagnoses, substance abuse histories or addictions, the commission of violent offenses and specific types of offenses, so things like sexual offenses or domestic violence, and then the stereotypes, again, that also might be amplified by associating some of these characteristics also with violence, which kind of further complicates the triggering of remorse bias as well. So let's talk a little bit about, we've talked about this kind of broad conception of what remorse bias is, and kind of how it might come about and some of the things that may trigger it. But let's talk about some of the kind of psychological theories that underlie remorse bias and why we think it potentially exists and presents in the way that it does. And so one of the things that I found in my work and that has also been talked about more generally is that one thing that we think is kind of at the core of remorse bias is something called fundamental attribution error. And so what this means is that when we think about ourselves and when we make mistakes, because we all make mistakes, obviously, when we make mistakes, we have a self-bias towards ourselves where we attribute our own errors and our own mistakes to situational kind of external factors that basically, suggest that it's a one-time thing. I made a mistake. It was an error of my judgment. It's not going to happen again. It was something, I was tired. I was rushing home. I, was hungry. I was, wasn't thinking things through. So where there is a reason or a situational kind of external pressure that may be potentially led to that harmful behavior. And so we often, again, when we make mistakes, we have a self-bias where we think that our bad behavior came from those external pressures as compared to coming from who we are. I'm not a bad person. I just made a mistake. However, when we think about other people, we often are much more likely to think that their bad behavior or their errors of judgment are actually coming from who they are as people, coming from unchanging internal factors like character or personality or their morality, and that those mistakes may be coming from an internal place as compared to this external, I made a mistake. I, again, wasn't thinking, I was hungry, I was rushing home. It was something that influenced me externally as compared to internally. And so when thinking about that kind of as a backdrop, the fundamental attribution error basically takes that a step further and says, I think myself, when I make a mistake, it's an error of judgment. It was a mistake. It was a situational problem. It wasn't because I was a bad person. It extends that bias to people that look like us and people that we identify as our in group. So the idea would be that there are people who, again, we might have who have look like us or have very similar levels of education or come from similar places, or have similar backgrounds and histories and a variety of other contexts. And we see those people and they remind us of us. And so when they make bad decisions, we are much more likely to those who we identify with or those that we feel like we understand, believe that that bad behavior is actually coming from that external pressure. That person just made a mistake. That person wasn't thinking. That person was rushing home. That person made an error in judgment. It's not because they're a bad person. However, for individuals that are outside those groups, so those that may be considered an outgroup member, someone who we don't have similarities with, someone who we don't have similar background features, life experiences, education levels, a variety of other things, we are much more likely to believe that their bad behavior is coming from who they are, from those internal places like character or personality. And we are much more likely to attribute their bad actions as coming from who they are as a person deep down in that internal place. And so thinking about that as how that maps onto remorse, it means that decision makers who perceive a defendant as outside their in group, so someone who doesn't remind them of them, someone who isn't saying things or doing things or acting in a way that's familiar to them or they're similar to their own backgrounds, they're much more likely to attribute bad actions or harms that have occurred to a defendant's true character, to the idea that that person who doesn't look like them, who's again potentially perceived as that outgroup member, that their bad actions might actually be stemming from who they are as a bad person, their bad character, rather than to it being a situational context or a mistake. And because of that, if that person is showing remorse, that person who we think that bad behavior is coming from that deep down inside place, we're much more likely to believe that he's showing remorse. He's a bad person. It means his remorse isn't sincere, and I doubt that it exists. And so in this context, we think about fundamental attribution error again as being a way for us to think that when someone is making a bad mistake or committing a bad behavior, that that's coming from who they are, and that if they have any sort of remorse towards it, it can't be real because they're just a bad person. We also think that remorse bias also comes from challenges with empathy. So empathy is again something very common. Everyone knows at least in some shape or form kind of what empathy might look like in your own background. When something has happened, you are appreciating how another person feels. You appreciate another person's thoughts. You might have someone who empathizes with you as well. Maybe when you're going through a hard time. And empathy is very helpful in emotional communication between humans, and that it really allows us to, again, connect with people, and it also allows us to kind of accurately understand another person's emotional expressions and communicate that. It also allows us to kind of understand how other people are feeling. So this has been described as envisioning other people's inner worlds, making it easier to feel how they're feeling. And in a remorse context, if we can empathize with a person, and we can see their inner world, we're much more likely to feel their remorse, if they're showing it. And in general, again, human interactions, there's a lot of evidence to suggest that it's much easier for us to empathize with people who we view to be in our in group. So again, those people that we identify with, that we understand with, that appear to be familiar like us. And so with those people, we're much more likely to be able to empathize them, feel and communicate our emotions with them, envision their inner world, and feel things like remorse when they're expressing them. But in the same way with fundamental attribution error, when we are encountering someone from an out group, from someone outside these in group or perceived familiar groups, the way it's been described before is dissimilarity may impede forgiveness. It's the idea that we have a lot of difficulties being able to understand and empathize and forgive and emotionally connect with someone who we believe not to be like us. And this has been described as issues with outgroup empathy in the psychological literature. And how it relates to remorse is kind of, as we've just been talking about, it may mean that decision makers may struggle to empathize with defendants that don't look like them, that don't feel similar to them, or come from similar backgrounds or experiences. And that means that defendants outside of what they would perceive as their in group are less likely to have their emotional content received in an accurate way by decision makers. They're much more, those decision makers are much less likely to relate to those defendants. And then when a person is showing their remorse, a defendant is showing their remorse, because they're, again, may have different backgrounds, different life experiences, and that may impede that kind of emotional communication between the two. It may mean that a decision maker perceives and sees that defendant showing remorse, but doesn't feel it or envision it in the way that they would expect. And therefore, they discount it or believe it to be false because they don't feel the emotion coming from it in a way that they might expect from someone, again, that they might be familiar with or someone coming from a similar background. So thinking about these kind of two core kind of social psychological features of remorse bias, I'm now going to talk to you a little bit about some work that I've done in recent years on remorse bias and how we've seen this phenomena kind of develop for different decision makers in the criminal justice system. So in 2022, I developed a model of remorse bias for probation officers. I was interested in how they assess remorse of clients and how they incorporate those remorse assessments in pre-sentencing investigation reports and their sentencing recommendations. And I wanted to see how these remorse assessments could be subjective, how remorse bias could be present, and how this could negatively influence attributions of character and then ultimately sentencing recommendations for defendants, particularly those who are being sentenced for violent offenses. So I interviewed a sample of 151 probation officers from across the US, and I found that there were particular qualities of defendants' backgrounds that triggered a remorse bias being exhibited. So for officers, it was maleness, so being a male client versus a female client, having a previous or current gang affiliation, substance abuse issues, mental health issues, having committed specific violent offenses, particularly domestic violence offenses, as well as sexual violence offenses, having an extensive criminal or violent record, and then also coming from particular cultures as well. So I wanted to give you a couple of quotations just so you can see kind of these examples of what I termed in my model that I created, violent signals in a defendant's background. So one officer who was female discussing her male client, she commented that a lot of times men will come in and definitely don't acknowledge any sort of problem, blaming the arresting officer or something. It almost seems like they don't even view some things they've done as criminal and are just super defensive about what happened to them. And I almost wonder if it's like a gender difference. Thinking about culture, some officers talked about having client loads with a significant number of clients coming from particular cultural backgrounds that were different from their own. So there was one officer, for example, who described that he had a largely Hispanic male caseload, and he himself was white. And he talked about how individuals within this caseload, that culture is one of the things that we're dealing with. A lot of Hispanic guys I have had are, quote, big macho. They'll come in and they just feel like nothing wrong with what I did and just keep doing it. And so ultimately, when I created this model of remorse bias, I found that defendants who had qualities like maleness or coming from particular cultures, but all the other qualities as well that I mentioned on the prior slide, the officers exhibited remorse bias by linking these characteristics in a defendant's background to implicit assumptions that the remorse that they were showing was false or that it didn't exist through two different psychological processes. And so it was really that fundamental attribution error, as well as that outgroup empathy error as well. And when remorse bias was exhibited in the way that I have, portrayed here on the screen and that we've discussed now, offices were much more likely to doubt remorse that was shown from defendants, and then also describe them as having poor character, having kind of that negative internal immoral core, and describe that in their sentencing recommendations. So for that fundamental attribution error, there were a couple things that kind of came to light. So in those instances, defendants with the qualities that I was mentioning, they were much more likely to describe to have kind of an ingrained criminal mentality and kind of having their, again, bad behavior come from these internal factors. So one officer said, I think if they have a history of criminal activity where they're creating victims, I think that they probably have a very slim to no chance of having any significant remorse. Violence history, I think, is somewhat reflective of their thinking and who they are. It's not to say that somebody can't change over time, but it's pretty darn rare. They also talked about these defendants having fixed, meaning unchangeable and innate, inherent violent belief systems that they often kind of have based on their upbringing, on their background, based on who they are, and how that kind of drives their behavior. So one officer said, I may say, are you remorseful for your actions? Or how do you describe yourself as a person? And they'll say, well, I'm not really a violent guy. I'll bring up the facts. If you're not a violent guy, then what happened here? And then they'll say, well, it wasn't really me, but I'll say it is you. Some of the things they also talked about with issues with outgroup empathy, they talked about having difficulties imagining the inner world or feeling of the remorse of these defendants with these qualities, meaning that they were much more likely to believe that the remorse that they were seeing, if they were seeing any at all, was not real. And so one officer said, you have no idea what's actually true and what's really not with him. He can say one thing and say he says he feels guilty and cry, and then the next breath out of his mouth, he's like, well, screw them. You're telling me you're remorseful, but you're still drinking every single day. You're not asking for help. And then also officers talked about really having difficulties reading emotional content in that kind of communication with their clients, and then also the potential high likelihood of misreading that emotional content of their remorse expressions. So one officer said, who was female, she said, men just don't seem to have the ability to feel remorse in the way that females do. Females generally are more emotional and they can express when they have remorse, and they'll do it in writing and they'll do it verbally. It's more challenging to get any real remorse or any emotion out of a male offender or believe it's real if they do. And then, as I mentioned, these kind of social psychological factors that underlie this kind of triggering of a remorse bias, this remorse bias leads to these negative recommendations for sentencing. One officer said, when I bring them into my office, meaning their clients, I'm going to say, I'm going to ask a few questions, get your side of the story. I start observing them. I look at the way they sit, I watch their mannerisms, movements, and I do that and I put it in my reports for the judge. And I just state that the defendant said he was sorry, but he really appeared to have the attitude that this process really has no bearing on his life. I put that in the report just so the judge has more understanding of what I see, because when you're there before the judge, it's like, Your Honor, I didn't mean to do this. I'm sorry. But I may let the judge know that this person is not remorseful. I say, Judge, you should really throw the book at them. And then another officer said, I think that everybody wants to believe that they would be remorseful for their actions, when in reality, true remorse is something that they, meaning their clients, meaning these defendants with these personal characteristics, the reality is something that they have no concept of, and they can't and they never will. More recently, I have also done empirical work on remorse bias with judges. So earlier this year, I published a paper where I interviewed 61 state court judges in the United States, where I developed a model of remorse bias for judges, where I looked to see what types of defendant characteristics, in the same way that I did for probation officers, what are the characteristics for judges that signal criminality and the likelihood that remorse is false, and linking those qualities to implicit assumptions that these defendants can't show remorse, that the remorse is false, and that this really, again, stemmed from the kind of exhibition of these two social psychological processes that I mentioned, that fundamental attribution error and issues with outgroup empathy. But for judges particularly, this idea that really normative cues, so again, like expecting to see see defendants show specific body language or say specific things or do specific behaviors or show a certain demeanor. That was much, much more prevalent in the sample of judges as compared to probation officers, meaning that judges appeared to really, really care about and look for those expectations of remorse and really rely on kind of conventional remorse cues and and the kinds of things they might expect in order to make assessments about a person's remorse. So some of the signals, some of the characteristics of defendants' backgrounds that triggered remorse bias for judges were age. So it was much more likely to be prevalent for younger adults, especially younger adult males, issues with individuals with substance abuse issues, people with lower SES or lower education levels, maleness, individuals coming from particular races and or cultures, especially if they're different from the judge, and then those with more significant, meaning longer criminal histories. So this was the remorse bias model that I created for judges. Again, it looks very similar to the probation officer model, except there were, again, some differences where, again, we were much more likely to see this kind of influence of these conventional displays of remorse, these expectations that judges had on what remorse should look like, kind of in this assessment process. And this also kind of led to these character attributions painting defendants in a negative light. And so when remorse bias was exhibited in this way, judges were much more likely to disregard that person's remorse, attribute criminality to poor character, and then also to think that how this should be integrated into sentencing, particularly making judges much more wary of sentencing alternatives or using probation or community-oriented sentencing as compared to thinking about using either incarceration or more traditional modes of social control for defendants who they believed kind of fit within the criteria that we're talking about. So I wanted to give you an example of kind of what one judge might say when he talks about kind of expectations of remorse. And so one judge said, I've seen most defendants show remorse by being accountable. They'll say, hey, judge, yes, I was guilty. So to me, that's the first step. The second step is they might say, judge, is it all right if I address the victim's family or the victim themselves? Third step, I've seen some defendants who write a statement saying that I want to let the victim know or the victim's family know that I am truly sorry or truly remorseful. And so what judges really, again, were looking for is they were looking for appropriate body language. They were looking for defendants to articulate responsibility, often verbally. They were looking for defendants to show what they believe to be appropriate emotions in a remorse context. They also were looking for defendants to show perspective taking in discussing or showing a recognition of their bad behavior. And they also were looking for the remorse to feel like a shared experience, meaning that they were expecting to feel that remorse in some sort of shared way where everyone in the room, they described, would feel the person and know that they were remorseful. And a lot of these expectations that judges talked about really, they said, came from their gut in the sense that they believed almost when I see it, I know that it's remorse. And as we've been talking about, this can be very, very dangerous because we know that remorse bias impedes that ability to read another person's or feel another person's remorse when they're not like us inaccurately. And so when a judge is talking about making these decisions from their gut, it means that they are potentially much more likely, again, to kind of fall prey to this type of remorse bias. So one judge, when talking about remorse in this kind of aspect of fundamental attribution error, they talked about criminality as being, again, coming from internal places, that they had very ingrained, unchangeable criminal mindsets. One judge said, let's say that someone killed another individual in an automobile because they were drunk. I've gotten everything from nurses, businessmen, mothers of four who kill someone in what we call vehicular homicide. It's not that group of defendants tends to be bad. They're good people. They made a mistake. They're not like the career criminals. They can truly feel bad about it. And so often what I would see is that judges would talk about kind of two groups of people, kind of thinking about like, here are the people like the nurses and the businessmen and the mothers and all the good people. And they're the people who have made a mistake. They're not bad people. They've just made a mistake. But then you have the bad people, the career criminals, the people who have, again, these qualities that I'm talking about, and they're the bad ones. They're the ones that the behavior is coming from those kind of ingrained places. When they talked about empathy, they also said that they, misunderstood the emotions and affective behaviors of the defendants with these qualities that I'm talking about. They said they had a lot of difficulty feeling the remorse, or they believed that there was a lack of remorse because they could not feel it. And so one judge said, it's kind of a gut feeling because to me, it's based on not only the words, but the look in the eyes, because eyes never lie, and body language and expounding on their remorse. I've had some individuals who have said they were sorry when I could tell from their mannerisms, the look in their eye, and the tone of their voice. And they were saying they were sorry to try to get a better result. I'm not a psychologist, and certainly I'm not infallible, but you do this long enough and you get to the point where you just know. So again, kind of going back to that gut reaction, in this case, a gut reaction to feeling that you need to feel that emotion. You know that emotion when you see it. And if you don't feel it, then it's not there. And again, when judges talked about these things, they often, again, defaulted to more punitiveness or harshness when thinking about making decisions or perspectives towards sentencing, about prioritizing retributive or deterrent punishments, things like, again, traditional methods of social control, jail, prison, that they were much more likely to believe that rehabilitation wasn't going to be helpful, and that also that it would be an aggravator potentially to a person's sentence, whether that be legally or kind of just more informally as something that might, again, heighten their punitiveness in sentencing. So one judge said, I feel that if they are just going through the system, not remorseful at all, then maybe a short stint in jail is how to sentence them. If they can't have the feeling that they did was wrong, then sometimes it requires a short jail stay to say, well, if you don't believe it's wrong, at least don't do it again. I don't want to use probation for somebody who's not going to be amenable to it. And if somebody has no remorse and doesn't think that whatever it is, they should just be a crime or have a variety of excuses for why somebody else was partly responsible. In my experience, they're less amenable to rehabilitation. So you do the best you can and you punish them in hopes that they will change the way they view it. So as I mentioned, I again did these two studies more recently, but there have been other individuals who have done work on remorse bias, even though it may not necessarily have been termed that. There's been research done in the Netherlands and Australia and by other individuals in the US. And then also there has been evidence of remorse bias, and again, maybe not necessarily termed that, in parole hearings as well, where there is, an expectation that a person might portray the remorse or talk about their behavior in specific ways. And then when that defendant isn't necessarily talking about or owning up to their behavior in a way that might be expected or might be something that would be applauded by a parole board when thinking about making a release decision, there could be potentially negative effects that could be triggered by this remorse bias influencing these release decisions. So thinking about then this existing remorse bias existing in the justice system and then having a potential influence on outcomes, the idea that remorse bias might create kind of more discriminatory or harsh outcomes for certain defendants appears to again be very, very pertinent. And this is especially important in stages of the justice process where there's more discretion and where there's more extra legal factors that can be at play in those decisions. Because we know that remorse assessments that are affected by remorse bias can also lead to character attributions that are biased and potentially inaccurate. It means, again, that we might see harsher sanctions based on, perceptions that a person's character is bad, that it's permanently bad, and that this person is a risk for future bad behavior, that this person isn't really showing emotions, and that this person, because they're not showing emotions in the way we would expect, that this person is callous, that they're remorseless, that they're a bad person, and this should kind of enhance their negative outcomes. And this not only, again, can be very negative in a sentencing context or in a legal context, it also can potentially have downstream harms that can reduce an individual's mobility, issues with social exclusion, and a variety of other things on the more societal and community level, especially as they reenter and reintegrate into society after a period of incarceration. And so, for the last part of the presentation today, I just wanted to talk a little bit about some tips for attorneys and also decision makers at large about mitigating remorse bias and the things we need to think about moving forward as it relates to remorse bias, and making sure that it doesn't affect outcomes for defendants in the ways that it potentially could moving forward. And so, the first tip I have is that do not rely on performance of remorse alone, in the sense that no one should assume, including attorneys, should assume that when a person is showing emotion or having verbal apologies, that they might actually be interpreted in a favorable or consistent light. In the sense that if someone is showing remorse in a specific way, it is not guaranteed that it is being assessed or received in the way that it is being expressed. In the sense that, especially if a defendant is showing it in a way that is potentially non-normative, or there are a lot of differences, again, between the decision maker and the defendant, it does not mean that the remorse, even if it's true, will be met positively. And so avoiding that is helpful, and that in the sense that we should not make those assumptions and rely on someone's remorse to be assessed accurately. Um, and it also means that emotional restraint, when we see someone not necessarily showing remorse in the ways that we would expect, they may not be emoting in the way that we would expect. It doesn't always mean that they believe that they're not responsible. It doesn't necessarily mean that they are not remorseful. It means that they might be showing remorse in a non-normative or different kind of way. So even though it might be interpreted that this person is not remorseful or is callous or doesn't care, it doesn't necessarily mean that that's actually what's happening if they're not showing emotion in a way that we might expect. And so one thing we can think about to kind of tackle this moving forward is that the remorse cannot be the only thing, and especially from demeanor or from kind of external ways that it might be shown in a court setting, it cannot be the only way that remorse can be inferred. The record and in general, a person's background and expectations about a client or about a defendant needs to be prepared or presented in such a way where the whole picture is shown. And so some things, that I have written here is that some of the common pitfalls that we've talked about, having conflating culture with character, ignoring behavioral actions related to remorse, relying on one's gut, having issues with empathy, attributing bad behavior to character versus mistakes, misreading certain types of characteristics like culture or trauma or mental health diagnoses as someone being callous, when in fact it might just again be a presentation of their different characteristics. All of those things, again, are potentially very problematic and can cause issues in remorse assessments. And so what we need to do is we need to focus on responsibility, repair, future orientation. So portraying a person and providing evidence that a person is responsible, is showing, again, the actions and behaviors that they're trying to make repair, and attempting to make, up for bad behavior, that they're thinking about the future and how their life might look like in the future. Also, again, contextualizing that individuals show remorse differently, that there are these contextual effects on displays of remorse, and that's really important for the court to understand. That people should not rely on their gut or their body language of another person or eye contact alone in order to make decisions about remorse. Demeanor is not going to tell you the whole story. And then also not conflating flat affect or a lack of emotion with a lack of remorse for all the reasons that we've talked about. The second tip is, we're kind of thinking about the issues with that kind of first area, especially focusing on demeanor and emotion, is really to reframe remorse as actions, not affect. So to counter remorse bias, attorneys should emphasize behavioral and contextual indicators of remorse when describing and presenting their client and their background in their case, especially during sentencing proceedings where a defendant might provide a letter to the court or maybe expressing themselves verbally. Courts again often will overvalue emotional expressions, and they sometimes will undervalue actions because again they're so focused on emotions, they're so focused on what's being shown in court as compared to what might be happening behind the scenes or plans for actions. This could be things that demonstrate accountability, like treatment engagement or compliance or voluntary restitution. All of those are really great and impactful ways to show remorse. And if they're argued and contextualized as ways that person is showing remorse, that can be really, really important to help provide a larger picture for the court on individuals and their remorse behaviors, and kind of the types of things that they're trying to do to move forward. And this is also framing remorse as consistent conduct. So people, staying out of, this person has a substance abuse disorder. This person hasn't drank. This person hasn't used substances in a significant period of time. This person has kept a job for a significant period of time. All of those types of things helps to reduce reliance on subjective emotional judgments. And so again, this really leads to suggestions about anchoring remorse in documented behavior and not just emotional displays. And so some of the prompts here I have here are sample prompts for assessing remorse, whether that be, having this when you're interacting with a client, but then also potentially when you're discussing or talking to other individuals in court, or potentially thinking about trying to allow defendants to be able to talk and provide information in the best possible way. These are prompts or ways in which you can think about information being communicated to the court. So one might be, tell me in your own words what you understand the impact of your actions to be. What steps have you taken or plan to take to repair the harm? What changes have you made to plan or to make or to avoid future harm? And then also, again, that contextualizing of emotional presentations, making it very clear and allowing individuals for you to fully understand, potentially as legal representation, but also for them to communicate to the court if there's anything affecting their ability to express themselves or their emotions in court in a way that maybe people would potentially expect. And then finally, the third thing is educating the court about bias explicitly and carefully. So this means that, remorse bias can be raised responsibly without accusing people of unfairness. Judges and decision makers that I've talked to this information about before have appeared to be very open and understanding that this is a phenomena that is likely to have an effect on legal outcomes. And so if you provide research-based explanations about remorse, this can really help decision makers understand how demeanor and communication can differ depending on defendant's background. And this again may mean that, bias education is framed as something that helps to aid the court in more accurate and fair decisions, and not something that is associated with blaming people for being biased, since we know that being a human being means that you're biased. It is not something that is, overly represented in any population. It's something that is going to just be true of anyone in our social world as human beings. And so some of the things that I've talked about in the past that could be related to remorse bias education. So this could be things like systematic observation and feedback, meaning that decision makers might be in a situation where they're observed for remorse bias and they get feedback on that and get to reflect on it. Decision makers also might be helped by learning about defendants and who come from these different backgrounds and how they might express and show remorse differently. So it might be that, people who have experienced trauma, people who have certain mental health issues, whether that be because of diagnoses or certain medications they're on, people who come from neurodiverse backgrounds, people who come from different cultures, people who come from different educational levels, all might show emotion and remorse differently than what would be expected or from people's personal experiences. And this again helps us to distinguish demeanor from sincerity. And it also allows us to engage perspective taking to expand our ability to empathize with other people. Because again, when we're much more likely to when people are much more likely to be able to perspective take effectively, they're much more likely to empathize with other individuals who are not like them. And so my conclusions here are, again, kind of some of the things that I would hope to leave you with about managing remorse bias as attorneys. Don't equate remorse with demeanor, meaning that if you see flat eye affect or limited eye contact or atypical emotions or a lack of responsibility or atypical emotions, it does not mean a lack of responsibility or that a person lacks insight or remorse. These, again, might be things that are affecting their demeanor or the ways in which they present themselves or communicate emotionally, but it does not mean that necessarily remorse is not there. If you have clients, making sure that they, as well as the courts, recognize that remorse would is again might look different on different people, but it's also very important to recognize that again, people who come from specific backgrounds, if they are put on remorse in ways that are not natural to them or things that are not true to who they are as people, it may mean that they may be showing emotional displays that are viewed as being coached, and that might undermine their credibility. And so it's something to, again, be very cautious about and be able to try to balance that in some capacity. Again, making sure that clients and defendants more generally are able to emphasize concrete behaviors, things that show that they've accepted responsibility, cooperated, been rehabilitative, and been focused on bettering themselves. And all of those are very helpful in showing how that behavior is remorseful and is potentially a lot more influential and should be given more weight than emotional or demeanor evidence. And then finally, flagging potential bias proactively. So when appropriate, explicitly note to the court that emotional presentations and that remorse displays more generally, whether that be verbally or emotionally, that this may look very different depending on the person who they are. It may look different across individuals coming from different backgrounds, cultures, neurotypes, a variety of other contexts. And for the court to recognize that, they are much more likely to take a step back and try to think about, are there things here that I might be missing or misunderstanding or misreading because of remorse bias, because of these differences in our backgrounds, or because of these expectations that I might hold? So this is the end of my presentation. I am going to take a quick look at the quick Q&A. So one person said we judge ourselves based on our intent while judging others based on their actions. And so that's actually very interesting. And I agree in the sense that you, again, are your own, you can imagine yourself and you can imagine the reasons why you may have committed a bad act. But it's very hard for us to see inside the brains and think about the minds of other people in making some of those decisions. And so, yeah, we're much more likely to judge them on the outcomes as compared to the intentions. So I totally agree with that. Another person said many neurodivergent people have difficulty in meeting anyone's eyes when speaking. How can we make the POs and judges aware of this? Wonderful, wonderful example. I actually do a lot of work on autism and defendants with autism and the difficulties they might experience in court. And this is something that very similarly, there have been a lot of issues with, where when an individual isn't showing eye contact, it's sometimes misperceived as them being in a situation where they feel that the person's not owning up to their behavior or they're trying to escape responsibility. And so the ways I've described it is that, again, trying to communicate in the ways that I was talking about towards the end of the presentation about how clients from these different backgrounds may be showing behaviors in different ways, and that those types of behaviors should not automatically be assumed to, again, be associated with someone being cagey or callous. And once the court is much more knowledgeable, or there's some basic level of understanding that a person with autism, for example, is not necessarily going to show eye contact in the same kind of way, I have found in my own work, and I've seen other people's work as well, that it suggests that they are much more likely to be understanding and appreciative of that information, and they're much more likely to discount kind of that original reading of the behavior as negative. So I think contextualizing that behavior is going to be really, really, really important. Another person said, besides the crime, what did SBF do wrong at sentencing? So this is a good question. I do not have enough time to talk about Sam Bankman-Fried in this, but the autism example that we were describing is also something that potentially is complicating to this, in the sense that, again, people who come from these neurodivergent backgrounds, people who, again, are showing particular behaviors that are not normative or not expected, are, again, maybe going to be in a situation where they are going to get more extreme legal outcomes. And I think the Sam Bankman-Fried case is a good example of some of those kind of neurodivergent characteristics potentially expressing themselves in a court context, leading to that type of sentence. And then another person said, can these biases be used as an advantage? And so that's a really interesting question. And the example might, it depends on the ways in which some of these things are presented and kind of, again, framed. knowing what you have here, it really allows you to kind of think about how your clients or how defendants are being perceived. And so I think it's not so much as an advantage in the sense that the bias itself is an advantage, but I do think it's advantageous for people to know how their clients might be misperceived. And so if it means that the advantage here is that a defendant has a much fairer justice process and has a much better likelihood of having a legal outcome that is maybe much more proportionate or consistent or uniform to other individuals who don't have those particular characteristics, then I would say for all means, I'm very happy that this is something that we're talking about and presenting. So I think it really depends again on how it's framed and how it's used. But I do think that anything that allows for us to understand our own biases and allows for the justice process to be fairer for particularly defendants who might be be vulnerable in different ways, I think is really important. So that is the end of my presentation. Thank you so much for your attention. My information, I think, is in the materials that I sent. If you have any questions, please let me know. It's an area I'm very passionate about, which you probably can tell, and it's something I'm going to continue to do work on. And I hope this was helpful for you. Thank you so much.
This concludes today's presentation. Thank you so much to Dr. Berryessa for joining us today, and thank you so much to our audience. Have a great day, everyone.